Assalamualaikum and good morning, doctor. I hope you doing well today. This is my group members, and we are from Group 1. Our group will present the cases under topic Printing Presses and Publication Act 1984 and Freedom of Speech and Expression. So, my name is NURUL NAJIHAN binti AZAMAM. My matric number is 1180263. And the cases that I will present today under topic Printing Presses and Publication Act 1984. Before I go further about my cases, I will explain a little bit about Printing Presses and Publication Act 1984. Printing Presses and Publication Act 1984 is a Malaysian statute governing the usage of printing presses and the printing, importation, production, reproduction, publishing, distributions of publication in Malaysia. It replaced the Printing Presses Act 1948 and the Control of Imported Publication Act 1958. Under the controversial law, all printing presses require a license granted by the Home Affairs Minister, will renew every year. So here are the cases that I will be presenting today under topic Printing Presses and Publication Act. The topic is Police Probing Book with Insulting Cover of Modified Malaysian Coat of Arms for Alleged Sedition 3 Others Law. This case from Kennedy was published on 30 June 2020, and the publisher of this news, Malay Mail. So the fact of the cases is, on 30 June 2020 at Kuala Lumpur, Bukit Aman confirmed the seizures of 313 books for alleged violation of several laws, including the Sedition Act, following complaint that its cover of a nude child flanked by human face, two tigers stepping on a crocodile, resembled the national coat of arms. That is related on the picture that I show. And the book is titled Rebirth, Reformasi, Resistance and Hope in a New Malaysia, and it is published by Gerak Budaya Enterprise Sendian Berhad, Strategic Information and Research Development Center. Its cover art is deemed insulting to a national emblem. Federal Criminal Investigation Department Director Commissioner Datuk Husin Muhammad said police received 32 complaints to date over the cover art and are investigating the case under Section 5 of the Emblems and Names Prevention of Improper Use Act, Section 8 of the Printing Presses and Publication Act 1984, Section 4(1) of the Sedition Act, and the Section 233 of the Communication and Multimedia Act. They have identified the printers involved in publishing, printing, and the times of the rate that has been done. Almost 1,000 has been printed. Of the 1,000 books printed, 313 were found to be kept in storage, which were subsequently confiscated, while the remaining 687 books have been distributed after purchase were made online, buy-in online. Datuk Husin Muhammad disclosed. Next, no arrest has been made so far, adding the police will be calling up the author, publisher, and several other individuals linked to the publication of the book. Next Sunday, after that, UMNO Youth Chief Datuk Ashraf Wajdi Dasuki argued the Home Minister to take action against the book and call for it to be banned. like the picture that I include in my slide. Subsequently, past leaders joined his call yesterday with information Chief Kamaruzaman Muhammad labeling the book provocative and allegedly threatening public order. Next, other groups have since joined the attack, including Datuk Seri Muhammad Azmin Ali, Lig Pemuda Negara, Youth Parliament Model Parlimen Belia, and Islamic Group Ikatan Muslimin Malaysia. Subsequently, Home Minister Datuk Seri Hamzah Zainuddin said imitating the coat of arms is an offence under Section 3(1)(a) of the Emblems and Names Prevention of Improper Use Act. So the book publisher has since apologized, saying it had no intent to insult the coat of arms, which its cover art, like the picture that I show. Published this news published earlier this year. The book features articles by political analysts and journalists and include report on the 2018 general election. That's all from me. Thank you.
Hello, my name is NURUL binti Rahman, metric number 118026. I would like to take this opportunity to talk to you about the cases under topic Printing Presses and Publication 1984. The topic is Malaysia Kini wins court battle over the print's license. These cases from Hafiz Yatim, published by Malay Mail. Facts of the case. The Kuala Lumpur High Court Appellate and Special Powers Division has quashed the Home Ministry's decision not to grant a publishing permit to mkini.com serial Berhad, which operates the Malaysia Kini news portal. In ruling the ministry's decision as improper and irrational, Judge Abang Iskandar Abang Hashim said the Home Minister's decision was misdirected as it exceeded the limit of its jurisdiction. Justice Abang Iskandar noted that freedom of expression through publication is a natural right and is enshrined in Article 10 of the Federal Constitution. He recognized the fact that the portal has won numerous local and international awards, and that this should not stop the authorities from giving Malaysia Kini a permit. Kini had applied for the permit under Section 6 of the Printing Presses and Publication Act 1984 to publish a daily named Malaysia Kini. The company had applied for a permit to publish 40,000 copies in the Klang Valley to be sold at RM1 Malaysia a copy, but the Home Ministry rejected this in August 2010. mkini.com therefore sought to quash the minister's decision and to obtain a declaration that the decision was unconstitutional. It named the Ministry's Secretary General, the Home Minister, and the government as the respondents. It has submitted in court that the executive and the government must be fair in its approach. Is this protected under Article 8 of the Federal Constitution, equality before the law. Lawyer Ken Shamuga, who represented Malaysia Kini, Shamuga said there was nothing wrong with giving a permit to the news portal as Malaysia Kini was not threat to the nation. The court recognized publishing a paper is part of freedom of expression, which is a right under the Constitution. This is a fundamental shift of the interpretation of freedom of speech in the country. Today's decision comes back on the back of allegation and reports by the mainstream media that Malaysia Kini is out to establish the government right. Commenting on today's decision, Shamuga said the minister's decision not to grant the publishing permit was in breach of the rules of natural justice, as he did not give any grounds in arriving at that decision. Shanmuga said anybody can publish a residence newsletter, a village paper, or association newsletter as they should be free to do so. Mkini.com Chief Executive Officer Premesh Chandran, who was also present in court, said the company welcomed the judge decision as Malaysia Kini has been online for 13 years and a newspaper would help the company reach out to much a wider group of Malaysians. He said he was glad the judge saw the publishing a newspaper to be a matter of right as opposed to a privileged decision of the Home Minister to issue a permit. Premish hoped that government sees the decision as means to create further room for freedom of expression. In a related development, National Union of Journalists General Secretary V. Anbalagan welcomed today's decision, saying it held the minister accountable to state the reason why an application is rejected. He said if in the past the minister's decision in not granting a permit could not be questioned, in this case, however, the ministry did not give any reason.
Assalamualaikum warahmatullahi wabarakatuh. How are you, doctor? I hope you are doing well. Okay, my name is FADZLINA binti MUHAMAD. My metric number 1180261. Okay, so today I want to present about my article under title of Freedom of Speech. Okay, so the title of my article is Two Men Plead Guilty to Insulting Agong on Facebook. Okay, this article on 30 March 2020. Okay, before that, I want to tell the definition of freedom of speech. Okay, the freedom of speech is a principle that support the freedom of an individual or a community to articulate their opinion and idea without further retaliation, censorship, or legal sanction. Okay, this also the term freedom of speech is sometimes used synonymously but include any act of seeking, receiving, and imparting information or idea regardless of the medium used. After that, the fact of case. Firstly, two men pleaded guilty in the session court at Criminal Sessions Court, Cyber at Kuala Lumpur, to insulting the Yang di-Pertuan Agong Al-Sultan Abdullah Riayatuddin Al-Mustafa Billah Shah on their Facebook account. Okay, so who names known as Oil Wee Seong and Nur Azhar as the person sweat OKS, that's mean orang kena saman in Malay, made the confession after the charge against him was read out by the court interpreter before the judge. Okay, so Oil Wee Seong, who is unemployed, was accused of using a Facebook account under the name as Some Oil, SAMOOI, to initiate and make the transmission of offensive communication with intent to annoy others at 7:39 a.m. on 1st March. Next slide. The remark will later read the Facebook at the Cybercrime and Multimedia Investigation Division, Commercial Crime Investigation Department of the Bukit Aman at 8:20 a.m. on 2 March 2020. That's me next day. Okay, after that, Nur Haizat, an online trader, was charged with committing the same offense on a Facebook account as Haizat Azhar, and the statement was later read at the Bukit Aman Commercial Crime Investigation Department also at 12:20 a.m. on 1st March 2020. Okay, so Ol Wisung and Nur Haizat made the plays after the charge were read to them separately by a court interpret before Judge M. Edwin Paramjoti. Okay, so this case, it is believed that both committed the offense after the Agong decision to appoint Tan Sri Muhyiddin Yassin as the 8th Prime Minister after the country political crisis caused the Pakatan Harapan PH government to collapse. That the provision of the case. This case charge were framed under section 233(1)(a) of the Communication and Multimedia Act 1998 at 588 and could be sentenced under section 233(3) of the same act, which carries a maximum fine of 50,000 or jail up to 1 year or both open conviction. Okay, and also both also be fined 1,000 ringgit for each day of the offense and continue after conviction. So in this article, unemployed was fined 6,000 ringgit Malaysia in default 3-month jail by the Session Court. Judge M. Edwin meted out the fine on Ol Wisung, who pleaded guilty to charge. Okay, so he paid the fine 6,000 ringgit Malaysia. For this section, which is section 233(1)(a) of the Communication and Multimedia Act 1998 at 588, okay, which is any comment, request, suggestion, or other options indicate communication false nature with intent of offense, threaten, or harass others. Okay, so for the person who commit an offense under this section, upon conviction, may fine not exceeding 50,000 ringgit or in prison for a term not exceeding 1 year or both, and shall also be liable to a future fine of 1,000 ringgit for each the day of the offense continue after the conviction. Is for the conclusion, in my opinion, the court should take seriously the symptom of such insult and state that freedom of speech to express an opinion should be reasonable, okay, which is using the proper language, manner, and moral. Okay, so that's all from me. Thank you, Doctor.
Assalamualaikum and hi Doctor. My name is NORMALYANA binti NAWI, matric number 1180-260. So the cases that I choose is about freedom of speech and expression. Introduction of freedom of speech and expression. Free speech. Free speech is the freedom to voice out our thoughts and expressions without restrictions. And free speech means we can say whatever we want. Then hate speech. Hate speech is the abuse of this freedom to harm others or speech intended to cause violence. And hate speech is when we say things that are offensive or harmful, targeted particular person or group. This the article that I take. The title is Freedom of Speech. Do not cross a line. Written by Saleh Buang, publisher New Straits Times, date 2 January 2020. Cases in late November, National Patriots Association Patriot President Brigadier General RTD Datuk Muhammad Arsyad Raji urged the police to monitor all hate speech and message pertaining to the ICERT, International Convention on the Elimination of All Forms of Racial Discrimination, rally on December 8. He was concerned about incendiary speech and message on social media might lead to chaos. On December 26, police arrested Jaringan Melayu Malaysia (JMM) President Azwaندin Hamzah after he threatened to attack a police station during a rally in Kelang, Selangor. Police also confirmed that Azwaندin would be investigated for making insults against Minister in Prime Minister's Department P.Y. Murty and Primary Industries Minister Teresa Kok. Azwaندin had uttered a derogatory term on Waita Murty and accused Kok of being involved in the temple riot and had links to the developer. Gerakan Rakyat Malaysia (GERAS), the rally organizer, later distanced itself from Azwaندin. GERAS President Abu Bakar Muhammad said he disagreed with Azwaندin and was upset that he did not comply with the conditions to speak at the event. Article 10 of Federal Constitutions. In the Malaysian context, free speech refers to freedom of speech and expression as stated in Article 10 of the Federal Constitution, which declares in Clause 1A that every citizen has the right to freedom of speech and expression. Free speech, which is available for Malaysian citizens only, is not absolute because that freedom is subject to several restrictions as set out in clauses 2, 3, and 4 of the same article. The subject of clauses 2, 3, and 4 of Article 10 is all citizens has right to freedom of speech and expressions. All citizens has right to assemble peace and without arms, and all citizens have the right to form associations. The freedom is restricted and certain issues like the status of national language, Malay special rights, the status of Islam as national religion, and others that we should not question as stated in the Federal Constitution. This means that we have the right to say whatever we like without breaking the rules or regulations that threaten the society and even causes any public disorder or riot. The law related with the cases. The law was passed to comply with the United Nations ICERT Convention. At the international level, there are 2 UN conventions containing provisions relating to hate speech. First, the International Covenant on Civil and Political Rights (ICCPR), which states in Article 20, clauses 2 that any advocacy of racial or religious hatred that constitutes incitement to discrimination, hostility, or violence shall be prohibited by law. 2. The Convention on the Elimination of All Forms of Racial Discrimination (ICERT), which states in Article 4A that all state parties shall declare an offence punishable by law or dissemination of ideas, based on racial superiority or hatred, incitement to racial discrimination, as well as all acts of violence or incitement to such acts against any race or group of person of another color or ethnic group or ethnic origin. Provision of the case to counter hate speech. The police now invoke section 504 of the penal code because intentional insult to provoke a breach of the peace, and section 506 because criminal intimidation for hate speech via social media. Section 211 of its 588 dealing with offensive content can be considered. So that's all from me. Thank you.
Okay, Bismillahirrahmanirrahim. Assalamualaikum warahmatullahi wabarakatuh. I am NURUL binti SHAINI. My metric number 11800264. Okay, today I would like to talk or to present my article about one case that related to communication law. Okay, so I will talk about case from my from the article. Okay, so the case is about Facebook rapper wins at Supreme Court in widely watched third case. Okay, so the publisher is US News and World Report. The author is Steven Nelson, staff writer, and at 1st June of 2015. So as we can see, there is a picture. So the picture is told about Anthony Joy Elwood applaud the Supreme Court's Monday ruling in favor of his client, Anthony Elonis, who has convicted of making threats after posting to Facebook violent message he says were rap lyrics. Okay, so now the introduction of freedom of speech in US. Okay, in the United States, freedom of speech and expression is strongly protected from government restriction by the First Amendment to the United States Constitution, many state constitutions, and state and federal laws. Okay, so the Supreme Court of the United States has recognized several categories of speech that are given lesser or no protection by the First Amendment, and has recognized that government may enact reasonable time, place, or manner restriction on speech. Okay, so the First Amendment's constitutional right of free speech, no restriction imposed by private individuals or business unless they are acting on behalf of government. Okay, so the First Amendment's freedom of speech right not only prescribe most government restriction on the content of speech and ability to speak, but also protects the right to receive information, prohibits most government restriction or burden that discriminate between speakers, restrict the liability of individual for certain speech, and prevent the government from requiring individuals and corporations to speak or finance certain types of speech with which they do not agree. Okay, so the categories of speech that are given lesser or no protection by the First Amendment include obscenity, as determined by the Miller test, fraud, child pornography, speech integral to illegal conduct, speech that incites imminent lawless action, and regulation of commercial speech such as advertising within these limited areas. Other limitation on free speech balance, right to free speech, and other rights such as rights for other author over their works, copyright protection from imminent or potential violence against particular person. Okay, restriction on the use of untruths to harm others. Okay, slander and libel, and communication while a person is in prison. Okay, so the fact of the case. Okay, the U.S. Supreme Court on Monday ruled in favor of a self-proclaimed rapper jail for making threats after he published violent message on Facebook about his estranged wife, an FBI agent, and school children. Okay. A seven-justice majority overturned Anthony Eloni's conviction, finding threat convictions must feature a subjective analysis of intent. The jury that found Elonis guilty was instructed only to consider whether a reasonable person would consider the message threat of violence. Okay, so the case pit speech advocates and a diverse coalition of activist groups who start with Elonis against anti-domestic violence advocates and the Obama administration. The majority overturning rulings from 9 of 11 federal appeal circuits found negligence, meaning a defendant should have known their message would be seen as threat. Okay, was not sufficient for conviction. But neither side claimed total victory. The court intentionally sidestepped whether recklessness, meaning a defendant knows statement may be seen as threat and disregard the potential harm, make someone eligible for conviction. In separate opinions, Justice Clarence Thomas and Justice Samuel Alito said courts would be confused about the omission. Elonis urges us to hold that the threatened statute and the First Amendment require proof of an intent to threaten, Thomas wrote. Rather than resolve the conflict, the court cast aside the approach used in 9 circuits and left nothing in its place. The majority firmly said the mental state requirement for conviction is satisfied if the defendant transmits a communication for the purpose of issuing a threat or with knowledge that the communication will be viewed as a threat. Elonis purport lyrics include a suggestion that his then wife protective order was not thick enough to bullet, and lyrics to an original song called Little Agent Lady, a murder fantasy about a female FBI agent who visited him after he wrote about massacring a kindergarten class. Okay, he was arrested in 2010 and convicted of making threat. He served more than 3 years of a 44-month prison sentence before his release in February 2014. At trial, Elonis insists he did not intend to threaten anyone but was merely blowing off steam in a manner similar to rapper Eminem, whose music features violent rants about his ex-wife and the others. Chief Justice John Roberts, who wrote the majority opinions, pondered during December oral the distinction between Elonis posts and lyrics of famous rappers. The Reporters Committee for Freedom of the Press and 9 other media organizations said Elonis' victory was needed to spare journalists from threat convictions, either for their opinion, commentary, or even just for publishing what could be considered threatening words from the others. The Electronic Frontier Foundation, the Student Press Law Center, and the Pan American Center said in a brief that social media has fundamentally changed how Americans communicate, making proof of intent a critical safeguard against threat conviction for posting to social media, expression of momentary or exasperation that once were communicated face-to-face among friends. The Department of Justice, victims' rights groups, and acting state attorneys general counted that highly manipulative abusers might get off the hook if an intent requirement were required. Okay, now we can see there is a picture. Okay, so the picture is Anthony Douglas Elonis, contribute photo of the morning call. Okay, so Anthony Douglas Elonis won a 2015 appeal in the Supreme Court when the justice found jurors had been improperly instructed to consider whether a reasonable person would find Elonis' social media post threatening. Instead, prosecutors had to show Elonis' intend the message as threat, the justice ruled. Okay, the case was closely watched as the Supreme Court's first look at the boundaries of free speech since social media websites such as Facebook and Twitter become part of everyday life. Okay, in 2015, the court's X1 decision did not address whether Eloni's Facebook posts were protected by the First Amendment, but whether the federal law regarding interstate communication of threats under which Elonis was prosecuted contains an implicit requirement to prove a writer's mental case. Okay, the Chief John Roberts, in his opinion for the majority, note that while the reasonable person standard is common in civil cases, it is at odds with the principle of criminal law that a defendant must have awareness of wrongdoing to be guilty of a crime. Okay, now I want to release about the freedom of speech in Malaysia and US. Okay, so the freedom of speech in Malaysia, Article 10 of the Constitution of Malaysia guarantees Malaysian citizens the right to freedom of speech, freedom of assembly, and freedom of association. Unlike comparable provision in constitutional law, such as the First Amendment to the United States Constitution. Article 10 entitles citizens to such freedoms as are not restricted by the government, instead of absolutely guarantee those freedoms. Okay, a Malaysian citizen has the freedom in expressing their opinion as far as they do not touch on sensitive issues which have been identified by the Parliament in Article 10(4). Okay, this is due to Malaysian law under Act 15 of the Sedition Act 1948. In Section 2 defines sedition as any act, speech, word, publication, or any other things which make such acts, utterance, words, publication, or thing as having a tendency to instigate. Okay, so in the Sedition Act 1948, 41A, it states that any person who commits or attempt to do or makes any provision to do or conspires with any person to do any act of inclination, incitement, or if so commit, will have a tendency to incite. And 41B, any person who utters any word of incitement, if found guilty and on conviction, shall be liable to an offence of a fine not exceeding $5,000, 5,000 ringgit, or imprisoned for prison for a term not exceeding 3 years, or imprisonment not exceeding 5 years. So the conclusion is freedom of speech or expression can, as long as it does not bring badness or danger to other people in the country. Okay, and then the freedom of speech also can be used to express an opinion on something that can bring goodness for everyone. Okay, so the last is the legal action will be taken against anyone who exceeds the limits of freedom of expression. Okay, to avoid any bad, any fighting, any can harm any people in the country. Okay, so that's all from me. Thank you.